If something happened to you tomorrow, would your family know what to do? Most people put off estate planning, and it can cost your loved ones time, money, and peace of mind. In this episode of the Living Rightsized Podcast, we're going to break down estate planning, why it matters, and what happens if you don't have a plan. Hey everyone, welcome to the Living Rightsized Podcast, where we talk about simplifying, downsizing, and living with intention. I'm your host, Joey Sampaga, here to share stories and expert tips to help you live right-sized at any season of life. I'd like to welcome our special guest today. We have Becky Cholewka with Cholewka Law. She's an attorney, national speaker, and she specializes in estate planning, trust administration, and uncontested probate. Today, Becky and I are going to discuss estate planning and the top estate planning mistakes most people make. Welcome, Becky. How you doing today?
I'm doing great. I'm loving the sunshine out here today.
Yeah, it's beautiful out there. It's not too warm yet.
Not yet. It's coming.
It's coming. All right. Well, Becky, let's get started. We'll start off with something kind of easy here. What inspired you to start working in this specific field?
Well, life experience is kind of the main reason. So when I was 19, my dad unexpectedly passed away. I was in college. He had a massive heart attack. I had always been thinking about being an attorney. I was inspired in junior high with Abraham Lincoln. Actually, I just loved that he was a self-made man, just wanted to help people navigate legal stuff. So I was headed down that road. But I think estate planning, especially just because of my own experience and having to deal with that at such a young age and seeing what happens when people plan and seeing what happens when people don't.
Okay. Well, I know this is a very general or vague question, but for those of the viewers who don't know what estate planning is, can you just kind of give us an overview of what estate planning is?
Sure. It's really trying to make sure that you are leaving things wrapped up for your family. I like to call it a last gift. And it has things to do with legal documents, such as wills, trust, powers of attorney. That's the legal side of it. As well as making sure, for example, you have your assets and passwords and liabilities listed to make it easier for somebody to pick up the ball if something should happen and to pay bills online, things like that. So it's leaving your legacy, your guidance to your loved ones. That's also part of it. Maybe family stories or personal goals for your kids or grandkids. That's kind of all part of estate planning. My side, obviously, I deal more on the legal end of it, but we also help a lot with what I will call the homework for clients. So getting everything in place to also make it easier for someone.
Sure. No, I'm sure estate planning is really important because, when my mother passed away, she really didn't have an estate plan. And not luckily, but luckily, she didn't own too much. So it wasn't that difficult. And she did have, inheritances prepared and all of that. And luckily we didn't have to go through an attorney. We didn't have to go through any probate. There was no properties that were involved. So anyway, I do understand that. Now, some of the things that you mentioned there were, just things like passwords for them to log in. I mean, that makes sense. And who would have thought of that, right?
As times change, right? So one thing that we've had to deal with in my own office, people do online bill pay now. So you might not have that bill that is going to the house through the mail. So when somebody dies, if we don't know how to get into your computer and to be able to access your online documents and files, we may not even know what your bills are. So we've had to hire computer professionals to break into computers, password, hackers, and it costs a lot of money to do that. But we kind of have our hands tied if we don't do a good job, leaving all these breadcrumbs for our family to find.
Yeah. Well, I know that death is typically a subject that we don't like to talk about. But what are the top reasons why people put off getting estate planning done?
Procrastination, by and far, year after year, is always cited as the top reason, and really high, over 80% reason. There are people that are afraid of just talking about their own death. Maybe it'll jinx them. And so that's sometimes cited as a reason why they don't want to start to plan. And you always just get those people too that are, well, I don't care. I don't care if it's a lot of work for others. Like there's some people that just don't care. Right. So those are kind of always the top three, the people that just, doesn't matter to them, the people that are just makes them worried or jinxed if they start to plan to begin with, but procrastination's the number one reason.
No, I can understand that. So with, if someone is preparing to, let's say, meet with you or an attorney, an estate attorney, what type of documents would someone need in order to have a strong estate plan?
So we always like to make sure as people are working with us, we make it really easy for them to come in because for some people, this is stressful. It might be the first attorney, they've ever met. So coming in just with general information, who their kids are, information about birth dates and anniversaries, and just general information to come in to start a conversation. We'll walk people through that entire process as far as, what are their goals? What are they trying to accomplish? But for most people, documents really fall kind of into two different categories. The first is documents that can help us while we're alive. So a lot of people don't think about this part of estate planning, but these are healthcare documents, powers of attorney. These are documents that allow others to act for us if we can't act or in emergency situations. So those are really important documents for anyone over the age of 18 to have. A lot of people think, I don't have a lot of money. I don't need to do anything. But car accidents happen, right? Healthcare crises happen. And those documents help say, who gets to make these decisions for us? What decisions do I want them to make? It helps us stay out of the probate court for guardianship conservatorships. So that's kind of the first kind of foundation documents we put into place. Then we have the documents that are also kind of the post-death documents. So this is your will. We only use your will when you die. So that is just a document of who's giving my stuff when I'm gone. If you have a trust as part of your plan, that document is a little bit of both. And with estate planning, beneficiary forms, that's not something that I do at your institution, but every institution that you have has a beneficiary form. When I die, I want this asset to go to whom? And that's part of creating your estate plan as well, is making sure that legal document is done as well at all of those institutions.
Wow. Okay. And so once someone has their estate planning documents prepared, you guys reviewed it, and then you have the estate plan, or at least the initial plan, and then you get it official. How often should someone have their estate planning documents reviewed?
So I always tell people there's kind of two things. The first thing is, what do I need to do? And the second thing is, what do you need to do? So I always encourage people to go in and speak with their attorney every 2 to 3 years, bring in your plan, let the attorney review it to make sure there haven't been any legal updates that need to be addressed in your plan. And those legal updates are things you probably won't even have heard of or know of. It's just because maybe a law changed at the federal level. Maybe there's an IRS tax code change that we need to address in your documents. But there's lots of things you need to do as well. And that's because this plan is really just based on your goals. So let's say your goals are changed or your people have changed. I always tell people, anytime there's a life event, so a death, a birth, a divorce, you've moved to another state, you've got a new huge investment like a new home, just pause and take a second and see if that has changed anything or if we need to address anything in your plan. So a lot of times that could be, I've listed my sister as my backup healthcare decision maker, but she now has dementia and she can't do that role anymore. So I need to go in and change my plan and add somebody else into that decision-making role. So again, I always tell people there's something I do, there's something you do. And even if you don't have a life event in any given year, I always tell people at the very least once a year, look at your documents, look at the people you've chosen, and just make sure those are still the right people in the right places.
Yeah, make sure that one of those kids didn't do anything bad to you, right?
Right, exactly.
Okay. Well, you mentioned probate. Now, as a real estate agent myself, I went to a transaction, then later found out it was in probate. And that was not a good thing. And this was just me being new to the business. So I really didn't know what to ask for. But for those who don't know what probate is, because sometimes when people hear the word probate, they're like, because, sometimes it takes a long time. So what exactly is probate?
Yep. Probate is a court. And we go to the probate court for a couple of different reasons. The main reason that people use the word probate is when we have to go through the court when somebody dies, and the court has to oversee the distribution of those assets. So probate is not a mandatory thing to go through as far as, everybody must go through it when I die. No, if you've done a really good estate plan, we get to avoid the probate court when you die. So it's all about making sure we have either beneficiaries listed on every asset, and or we also have a trust in place and we've titled assets into the name of our trust. If we've done one of those two things on everything, then we get to avoid the probate court when you die. The second part of probate, however, people don't often really think about, but it's, do we have to go through the probate court if we become incapacitated? And those are called guardianship and conservatorship actions. It's still done at the probate court, which is why we still refer to it just generically as probate. But it's when the court has to legally now appoint someone to either make your healthcare decisions or to make your daily decisions, manage your monies, things like that. So those are both separate types of probate processes. Here in Arizona, the death probate is on average about 9 to 18 months. I would say for a simple probate where there's no family fighting, there's no complex issues that we're dealing with, you're looking at probably $5,000 to $10,000 for probate.
Okay.
If you are going through a guardianship or conservatorship action, you're probably looking at $4,000 to $7,000 to go through that process.
Oh my goodness.
And those processes take, 3, 4, 5 months, depending on if it's heard on an emergency basis.
Wow. So typically then is probate only for those who really don't have a good estate plan or have an estate plan at all?
Yeah, typically for those that either haven't planned or haven't planned well is when we're usually in probate. So I have clients that have done fantastic estate plans, but haven't kept up on them. And when you don't keep up on them, the likelihood that something is going to fall through the cracks that we haven't addressed it becomes more probable. And a lot of times that's the time when we're ending up in the probate court. And I'll give you an example.
Okay.
When clients do a trust, and this is one of the biggest estate planning mistakes we see across the country. When people have a trust as part of their plan, that's kind of step one is to create the legal document itself. And step two is to retitle your assets into the name of your trust. So for example, if I have a swimming pool, if I've built that pool, but I've never filled it up with water, I don't really get to enjoy and use the pool as I anticipate, right? It's the same thing with the trust. If I don't fill up my trust with all of my assets, I don't get to use it the way it was intended. So trust funding is really important, and people forget to do that all the time. So they get their plan done. 4 years goes down. They've never gone back to their attorney and never had a conversation of, well, what are your new assets? How did you title it? How did you open up that new account? Did you put a beneficiary on this? You bought a new property. Is it titled in your trust, or did you do a beneficiary deed? Making sure we have everything lined up with your trust is really important.
Okay. No, that totally makes sense. And then, being a real estate agent, of course, when we get to title, they typically ask, let's say a married couple, how do you want to hold title? Now, what is usually the best way to hold title? Let's just say they love each other. They're not fighting, and they just say, we don't want this home or this property to go through probate. What's the best way to hold that?
For a little other caveats, because of course the legal lawyer answers, this is, not legal advice, not intended for everyone's stuff. But typically the default, if you don't know what to choose, if you're a married couple here in Arizona, it would be community property. And I like community property with right of survivorship. And what that means is when the first spouse dies, the second spouse owns it 100% without going through the probate process. So the surviving spouse still needs to record a death certificate and needs to record what's called an affidavit of the surviving spouse. But that's just recording a few documents. That doesn't take a lot of time and money to deal with. If we just have community property listed on the deed, which we see this mistake a lot, how property is titled is really important. Depending on the situation, again, community property. Let's say my husband dies. Well, now 50% of that house goes through the probate process, his 50% of the community. I still own my 50%, but now we have to address his 50% through probate, which is why I love those. I call them the magic bean words, with right of survivorship. That keeps us out of the probate court.
Sure.
But caveat with all of this is blended families are pretty complex situations to deal with. And if we just put that term on, and just so you know, it might frustrate a whole bunch of other goals and planning, just because with right of survivorship, whoever is the surviving spouse gets 100% of that house, which may be what the clients want, but it may not be.
Yeah. No, that makes sense. Yeah. Again, I was just thinking back right now when my mother passed away. Our family, we were pretty tight, and there wasn't anything that we really fought about in regard to anything big. We were all pretty in agreement. We were in agreement. However, there were little things, like she had a camera, for instance, and my grandnephew took it. And I was a little upset about that. I was like, why did you just take it without telling me? I mean, just the little things like that. And not that we would ever, because we were all friendly. We loved each other. But it's like when someone passes away like that, sometimes your emotions just kind of get away from you a little bit.
Yeah, we all have stories about things that have walked away from the house after someone has died, right? It's sadly very common. And not all families are like yours and get along. And so there's a lot of also family dynamics that come into play. But fighting over the stuff is really common. I have seen trials where people are in probate court fighting over china. Not necessarily because of the china, but because the brother and sister hated each other, right? And they just wanted to make it miserable for the other. So there's a couple of tips that I always like to offer folks, that when you do a will and a trust here in Arizona, there's another document that you get to write down a specific item to a specific person. So my piano to my granddaughter, Susan. That's a great way to help make sure that people are getting what they've wanted. But then it also means you need to ask people in your family, hey, is there anything that you want? Which is also a loaded question for some families. And so this is very common. Well, Mom, you're never going to die. I don't even want to talk about that.
Oh, boy. Yeah.
Well, but we need to, because Mom will die someday. Or there's always, two kids want the same thing. So in my office, I've actually had family situations where we have flipped a coin. We played high card draw. Just find ways for us to stay out of the court and still make it a fair process for everyone. But it's always easier to address those types of things before someone dies. So I always encourage my clients to have these types of family conversations, even if it's hard, even if it's awkward. It will save problems down the road. A lot of problems down the road. Yeah. Earlier you mentioned trusts. Now I heard the term revocable and irrevocable living trust, revocable living trust and irrevocable trust. Can you explain the differences between the two and what they are? So people try to overcomplicate this a lot, but it's pretty fairly simple in a general sense. So irrevocable is kind of just what it sounds like. Can't revoke it, right? It's irrevocable. Revocable, you can revoke it. You can change it. You can amend it. So there's actually about probably 40 to 60 types of trusts. But they pretty much fall into those two categories. Is it a document that you can change, amend, restate, make changes to, revoke, or is it a document that you can't? And there's different reasons for doing those two different types of trust. So in a estate planning world, the typical trust that we're going to see is the revocable trust or the revocable living trust. And that's because it's a living, breathing document that clients have full control over and gets to change. Types of trust on the irrevocable side, we're really doing those for specific reasons. Maybe it's for tax planning purposes. Maybe it's a Medicaid asset protection trust. maybe it's a special needs trust that we're doing. So there might be some specific reasons why we're choosing to do an irrevocable trust, but those are less common. The most common estate planning tool is the revocable trust.
Okay. We recently had a friend who the husband passed away, but the mother or the wife did not get along with the adult daughter. And from my understanding, they had a revocable living trust, but when he passed away, it turned into an irrevocable trust. So the mother was trying to not give anything to the daughter when she passed away, but because it turned into the irrevocable trust, she couldn't change it. Is that kind of the way to use it as well?
A lot of it depends on specifics. However, when I'm a trust maker, if I have a joint trust with my husband, in Arizona, we do a lot of joint trust because we're a community property state. So when I do a joint trust with my husband, it depends on what we've stated in the trust. Does it all go to the survivor's trust, or do we keep my half into what I will call the marital trust, right? So it depends on what kind of trust you're creating. Or if it's an individual trust, if it's just me, when I die, it becomes irrevocable. But as to my husband and I, it's irrevocable if I keep my half separate in a marital trust. If I just say my half to my husband's survivor's trust when I died, then that survivor's trust is still 100% amendable, revocable by my husband. He now has 100% in his trust, and he can go do whatever he wants. So it really, it depends on how the trust document is created.
Sure. No, that makes sense. All right. So I'm sure there's a lot more things we can talk about here with limited time, of course. So let's jump into the estate planning mistakes. Now, I was sent a flyer from your law firm, and it gave the top 8 estate planning mistakes, and number 8 was procrastination. But what are the other ones that you'd like to bring up?
So we talked about one, actually, titling property incorrectly. So people that don't have with right of survivorship on a deed, if it's owned with their spouse or, family member, that invites probate. So we don't like to see that mistake made. We also just see mistakes done like quick claim deeds. We don't like to do here in Arizona. It actually can break your title insurance, which is a bad thing.
Oh, interesting.
So I see a lot of people just kind of do it yourself for a quick claim deed. And I always cringe when I see those, especially if there's a mistake made in the legal description on the deed, which is a huge no-no. That's a big mistake from real estate. I'm sure you realize that. So that's one of our big mistakes that we see a lot. This is a big one. Adding adult children onto our assets, bank accounts, real property, whatever it might be. And for example, you walk into a bank, and maybe you're older now, maybe your spouse died and it's just you, and you're like, oh, I really just want to make it easy. I want somebody to help me. I don't have a trust. And so the banker will a lot of times say, oh, well, why don't you just add your adult child onto your bank account with? Happens every day. Unfortunately, that banker just gave the unauthorized practice of legal advice, which was not good legal advice, sadly. Because what you've just done, if you have listed your daughter now as joint owner on your checking account so she could help you pay bills, if daughter gets in a car accident and gets sued, this is also now her account. And you just lost her account in her lawsuit. Or your savings account, or your brokerage account, or part of your house, or daughter files bankruptcy, is going through a divorce. All of that now can expose your asset to their creditors. And that's a huge mistake. So we are counseling clients about that probably every week, about some other ways around that, because that one is a pretty high cost if you lose your bank account all of a sudden.
Yeah, well, that's what my mom did. Was she made me the joint? I was part of the joint account, so that if anything did happen to her, it'd just all go to me. But I didn't, good thing nothing happened to me. Right. So what is the best way around that, or what? How should that be handled if, let's say, the parent is a little bit older and the son or the daughter wants to help them out? I mean, what's typically the best way to help, pay for bills?
The best way is with a trust. And the reason for that is when we have a trust, we have those liquid accounts, checking, savings, brokerage accounts, titled in the name of the trust. And what that means is if I'm now incapacitated, whoever is my backup trustee can come in and legally act on that account. There are other things that we can do, but that is the best protection against incapacity or to have somebody help us. The second way is to add somebody as a joint owner, which we frown upon for legal reasons. You can also add someone on as a signer onto your account, which has less problems because those are joint owners on your account. However, a signer, just like having a financial or a durable power of attorney, if the bank finds out that you are incapacitated, they can close down those signing privileges as well. So it may not outlast your incapacity. This happened at Wells Fargo, actually. Another big thing, a mistake is people think that just having a financial power of attorney or any legal document means it's going to work. That's not true. So there's no law that says a bank or an institution must accept a power of attorney if you present one to them. So a bank can look at it and go, I don't like it. We're not going to allow it. Chase Bank, their internal policy is they won't look at a power of attorney if it's more than 6 months old. Wells Fargo won't look at a power of attorney if it's more than 1 year old. So just relying on just having a document doesn't mean it's going to work in every situation, which is why in this case, having a trust is your best protection to avoid the probate court, because we do have a state law that says the bank must allow the successor trustee to act. That's
wow. Okay. Definitely learned something there. All right. So how about, there's some DIYers, right? Do-it-yourselfers, with creating their plans online. Like, I can't even think of the, those
like
online
Zoom
ones.
would be one.
Yeah.
Right.
LegalZoom. Yep. What are your, recommendations or non-recommendations of those?
So on my office window, as you walk into my office, it says solutions, not documents. And again, estate planning is not about having a piece of paper. It's about having a piece of paper that works. So if you're looking for a piece of paper that works, I would highly recommend going to somebody who is in this field on a daily basis, because it's not just about, you can get free documents online all day long. You can have AI generate documents for you at this point, right? It doesn't mean they're going to work. And people get this like false sense of security thinking, oh, I have this document, I'm fine. Not talking to an attorney and realizing, well, how does this or does this not work? And here's an example of something crazy. Healthcare power of attorney. So a lot of my clients go to Mayo Clinic when there's something going on, right? So the Mayo Clinic, their legal department was looking for specific legal language in a healthcare power of attorney. It's not language that's required by state statute. It's just what their legal department in Rochester, New York, or wherever they are, was looking for. And so they kept getting denied to being able to use those healthcare powers of attorney. So as a specialist, I work with other attorneys in Arizona that specialize. And we've had actually one of our people, Chuck out of Prescott, went to the legal department in Mayo and said, what do you need to see? And we've actually drafted into our Arizona healthcare power of attorney legal language from another state, just so that our clients can use it here. So just because you have a document and just because it's executed properly and it meets all the requirements for a legal document doesn't mean we're going to have it be able to work out in the real world. So DIY, if all you want to do at the end of the day is have a piece of paper, great, do it. If you want a piece of paper that works, I would highly recommend working with a specialist.
No, that makes complete sense. And that's how I feel about for sale by owners.
It's the exact same thing. Yep.
Yeah. Okay. And then one other thing here I wanted to mention is leaving property to minor children. So explain the mistake on that.
So for example, let's say on a beneficiary form or through a will, you are leaving monies to your minor kids, okay? Anything that's going through a beneficiary form or through the probate court is just going to be basically closed down. It's going to be held in a restricted account until that child turns 18. The child not only has to go through the regular probate process, but we also have to go through a guardianship conservatorship process, depending on the dollar amount that we're leaving to that child. So there's now two court processes that we're paying for. So a lot more money spent on the probate court. And whatever that dollar amount is, when they turn 18, they're just going to get that check in hand. The statistics are, no matter what amount you are given, in about 3 to 6 months, if you are 18 and inherit money, that money is gone.
Yeah,
so
I can see why.
If your intent is just 10 to 18, I don't care. They can have whatever. If they blow it, they blow it. That's fine. That's the plan you want. If that's not the outcome that you want, we really need to start talking about adding a trust into your plan. And that's because through a trust, we can put in some more restrictions and parameters. Hey, somebody else is going to manage their money until they reach a certain age. Like in my particular trust, I have one son. He can't act as trustee of his bucket of money until he's 30. Someone else is managing it for him. I have a whole bunch of guidance in there of how I want them to spend money on his behalf. So there's lots of different things that we can do rather than here's your money at 18 and go blow it in 3 to 6 months.
Okay. No, that makes complete sense there. Okay. So those are the, some of the mistakes, that, people make with estate planning, but I just want to mention the 8 that's on this flyer that was provided to me. So number 1 was dying without a will. Number 2, not funding your trust. Number 3, leaving property to minor children, which we just talked about. Number 4, not updating your documents, and you suggested to do that every 1 to 2 years, correct? Or if there's a big major life change. Number 5 is creating your plan online, the DIYers, right? And then number 6, titling real estate property incorrectly. And then number 7, adding your adult child on your bank account, which is something that was new to me. And then number 8, procrastination. Those are definitely, that's good information that we can use. And by the way, if you want a copy of that, that flyer, I'll have it in the show notes. You can click on the link there and you can download it from there. And of course, if you have any questions, you can give Becky a call. So Becky, before we actually jump into our next round or our next segment here, which is a quick fire round, what advice, and we've probably already mentioned it, but just to rehash it here, what advice would you give to our listeners who don't have an estate plan, and how should they get started? I mean, like, what's their first step that they ought to take?
Well, thinking about things is important. Think about, who do you even want to be a decision maker if you can't make healthcare decisions anymore? For some people, that's easy. For some people, that's a little bit harder to even just kind of get through that thought process. But a couple of other just quick things people can do without even seeing an attorney. Make sure that you are putting beneficiaries on all of your assets. So go to your bank, call your life insurance company. We have a free beneficiary form for our vehicles here in Arizona. A lot of people don't know that. It's right on the NVD website. So make sure you're updating beneficiary forms for all of your assets, all of the ones that you can. And then another little quick tip is start writing down, what are all of your assets? What are your liabilities? What are your passwords? Just take out a piece of paper. I'm a paper girl, or you could do an Excel spreadsheet, but just start, pad to pen, or, start typing away and start leaving those breadcrumbs for your family in case something should happen.
No, that makes complete sense. I like that. I personally have a document, and my wife knows where it's at. It says, in case I die, and it kind of just gives her instructions on who she needs to contact. My passwords are on there. So no, thank you for that. Okay. So, are you ready, Becky, for the quick fire round? We're going to have some fun here.
Ready.
All right. Okay, here we go. If you could have dinner with any historical figure, who would that be?
Abraham Lincoln.
Abraham Lincoln. Okay, you kind of mentioned that one earlier. Yeah. All right. What's a book you think everyone should read?
Mindset by Carol Dweck.
Mindset. Okay. I'm going to have to take a look at that one. Okay. And then if you weren't an attorney, what career would you want to do?
I will probably even still do this in my lifetime. I've always wanted to teach. So I love educating. I do a lot of continuing education for attorneys and tax people and financial people and I would probably love to do some type of higher education teaching.
Okay. Okay, good. How about this one? Favorite sports teams?
So the Phoenix Suns,
Okay.
the Cleveland Indians, who I used to work for, I will always call them the Indians, not the Guardians. I'm a Cleveland Browns fan, have been since I was a little kid, but I've also rooted for the Niners. And Brock Purdy lives in my town, so his family's from here, so I will continue to root for the 49ers.
Okay. Okay. Well, my wife's favorite team is the 49ers.
Yeah.
And she is a native here in Phoenix, but her excuse is, well, they didn't have a team when she, grew up. So
Right.
it was either the 49ers, San Diego Chargers, or Dallas Cowboys, I
Right.
think were the ones, or Denver. But she's a 49ers through and through. Now, I actually grew up in California. 49ers were my team, but I lived here longer in Arizona, and I was just like, okay, well, it's time for me to root for the local team. So I'm an Arizona Cardinals fan.
Yeah.
In your bio that was given to me, it showed that you were a Cleveland teams fan. Are you into the Cleveland Browns at all?
I have a huge preference. Just watched the draft, and now I've got the whole, Schumer Sanders, debacle and stress about that. So, no, my dad's side of the family is from Cleveland. So I visited there when I was 16, when I was growing up. And my Browns were my first professional football team. Cavs were my first professional basketball game that I ever went to. Indians was my first professional baseball game I ever went to. So I will always root for Cleveland sports teams.
Yeah, I hear you. All right. Well, Becky, we talked about estate planning. We talked about probate, top mistakes that people make. Any final words of advice or things that we didn't mention that you want to mention here?
I always like to tell people, they're like, oh, I need to think about it. Okay. And then next week, you're going to think about it. And then a month from now, you're going to think about it. And the whole procrastination thing is going to keep going and going and going. Christmas time, they'll maybe think about it again, but then it'll be Christmas time and then you won't think about it again. Estate planning is one of those things I've lived it. The unexpected happens. And if your goal is to have peace of mind that you're doing right by your family and leaving them in a better place than without having an estate plan, I really just encourage you to start taking some of these steps, because every little step you take will help.
Yes. Well, Becky's information will be in the show notes. But Becky, if someone wanted to contact you, what's the best way that you'd want them to do that?
Yeah, I have the website. It's gilbertlawoffice.com. We have lots of videos, I have blogs up there. We have a free resource guide that you can download as well. There's just lots of great information. Our contact information is on there as well.
All right. Perfect. Becky, that was such great information. And for everyone who's listening, if you found this information valuable, please do us a favor, subscribe to the channel, like this video. If you know someone who could use this helpful information, please pass it on. Becky, thank you for joining us and educating us about estate planning and probate and all of that. I'm sure our viewers have learned a lot. I know I have, for sure. And for everyone out there, if you have any questions or would like to connect with Becky, her contact information will be in the show notes. And we would love to hear your comments. So please post them in the comment section below. Becky, again, thank you so much. I appreciate you.
Thank you as well.
All right. Until next time, have a great day. Take care and God bless. Bye now. All right. Becky, you were awesome. Thank you.
That was fun.